The case is now being recorded. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone, and welcome to the final case of the September 6th, 2022 Massachusetts Appeals Court sitting in Boston. The case we are to hear last is 21P0690 Diplomat Property Manager LLC versus Himes. The time clock should appear before us shortly, and when it does, Attorney Wasser, it will be your turn to argue.
Attorney Wasser, you're all set to go.
We don't see the timer.
Oh, you don't?
Sorry, Matt, we don't.
We don't have the timer, Matt.
Oh, all right. I apologize.
There we go.
All right. Whoop.
There we go. Okay. Attorney
Okay,
Wasser.
good. Thank you. Good afternoon, honorable members of the panel. May it please the court. My name is Attorney Brian Wasser. I represent the defendant, appellant James Lozano. In the context of this appeal, it concerns two competing titles. Unlike Diplomat's chain of title, the validity of the Lozano's title, chain of title, has never been in dispute. Their problems arose when the prime rate meltdown occurred, and which crippled our economy. They applied for and qualified for a loan modification under the HAMP back in 2012, and were ultimately denied a modification on the peculiar grounds that their loan had been paid off and not by the Lozanos.
Can I just ask you though, Mr. Wasser, all of this argument, wasn't it resolved by the prior appeals?
No, there was one prior appeal that that involved in the sixth lawsuit. This case that had to do with an anti-SLAPP statute. It was a interim pending appeal.
Okay.
And so, so contrary to how this denial of the loan modification had been couched by some of our adversaries as this one-time, clerical error on a single piece of paper, nothing can be further from the truth. In reality, the sophisticated gatekeepers of the Lozano's mortgage loan were, excuse me, sorry about that. The sophisticated gatekeepers of the Lozano's mortgage loan were held to holding Lozano's hostage under this position that they maintained for this time.
Counsel, if I may interrupt, could you point to me in your current brief where you have made the argument that you're currently making? Could you give me the page number of the brief where this argument was made, and was this argument also made in the Superior Court?
Well, I'm not really making an argument per se, Your Honor. I'm just pointing out the context. So I'm going to get into the subject matter jurisdiction issues, which is paramount in this case.
15 minutes will go by very quickly, and you have filed a number of issues. You can't issue for the first time on appeal at oral argument, so please concentrate on the arguments that you made.
Thank you, Your Honor. So as Your Honor compares Record Appendix page 252 with Record Appendix page 254, you can see the denial of the loan modification and the first lawsuit in this sixth lawsuit saga filed by the insurance company UGRIC. And that's the critical point here, because UGRIC is the subrogated to the rights of their insured, which is whoever the mortgage holder is.
Well, I understood that the motion judge took the position that this subrogation issue was not properly before him because there was a lack of a counterclaim. They were also the title holder under the second mortgage. Yes or no?
No, actually, I would say no to both parts. The lower court seemed to want proof that UGRC held the mortgage and therefore show that they had the right to release the mortgage or settle the mortgage.
We're
But
talking
they're
about the first mortgage or the second mortgage? My question was, did they
first
hold
mortgage.
the second mortgage?
To my knowledge, they did not hold the second mortgage either. They're just an insurance company. They're in the business of private mortgage insurance, not note and mortgage holding. And so, yeah, I'd say that's a good question as to how they even come. Sorry.
Which argument are you arguing here? You have several, so it'd be helpful if
Yeah.
you would tell us which it is. Are you talking about the scope of the UGRIC release right now?
I'm arguing, I'm just putting this in context. I'm arguing that the fact that Diplomat,
You're
Yes,
10
Your Honor.
minutes in. I'm asking you to go
Yeah.
directly to your arguments.
yes, Your Honor, Diplomat lacks jurisdiction and standing to bring a summary process action because they're a remote purchaser. They were not the purchaser of the foreclosure deed at the foreclosure auction. The summary process statute, chapter 239, section 1, limits summary process only to parties who purchased at a foreclosure auction when we're talking about the foreclosure mortgage context.
Well,
get around-
I read that argument with some interest, counsel, but all of the cases that you cited arise before 1950, haven't been cited since 1941, and the statute was amended in 1952, and the SJC cases in this century do not seem to draw the distinction you're drawing, although I would say that they don't directly address your argument. So
Yes,
what do we do with the fact that the SJC appears in its current cases, like Eaton, to have abandoned this notion of the direct purchaser and moved on to any party who holds title? What do we do with that?
yes, Your Honor. So I think that the cases we say are still good law. We haven't heard from the SJC on this issue in a while.
What do we
The
do with the
amended-
1952 amendment that changed the language of the statute?
So the amendment that changed the language of the statute pertains to purchasers and buyers and sellers in a purchase and sale agreement. And so Diplomat is making that argument, saying, well, we purchased the property from PennyMac Mortgage. And while that's true, that would allow them to bring a summary process action against PennyMac Mortgage because now they have privity of contract via their purchase and sale agreement with PennyMac. They don't have any privity of contract with the Lozanos. The Lozanos, under this facts of this case, this is a mortgage foreclosure matter. And so the 1950 amendment only pertains to a buyer and seller transaction where the seller sells you the property and then doesn't give up possession. The Lozanos, the Diplomat also argues that the Lozanos somehow were held under PennyMac's title, and that's how they get into avail themselves of the summary process. But that's also not true under these facts because the Lozanos actually dispute PennyMac's claims to their title. They have no privy contract with PennyMac either. They're not their tenants. They don't hold under their title. Their possession of the property predated PennyMac's rights, the time that PennyMac claims that their rights even arose. The Lozanos.
If you're right,
Mhm.
then Eaton was wrongly decided. HSNBC versus Morris was wrongly decided. Rosa and other current SJC cases were wrongly decided. And MERS is out of business because MERS has been holding title to these mortgages, selling to itself, and then passing the mortgage along to other buyers who you would consider to be remote. So how is it then that we reconcile these older cases that arose before the era of modern conveyancing with
I don't.
the reality of how foreclosures are conducted and the SJC's apparent endorsement of the current reality?
So respectfully, I don't read those SJC cases as being contrary to the proposition I'm making. Those are matters dealing with a buyer-seller arrangement, not someone who's holding, like MERS doesn't hold possession of someone's property. And so there's never a summary judgment, a summary process action that would apply to bring against a company like MERS. That has to do with a buyer-seller purchase and sale transaction. Actually, with MERS, I think we're talking about assignments of mortgages. That doesn't come up in the summary process statute at all.
That's true, but it impacts who holds the title. And what you're saying, what Wayne Investment Corp in 1966 says is what matters is who holds the title. And that's what the subsequent SJC cases say. It just matters who holds the title, not who's trying to, and the title holder has to be the entity affecting the summary process. And what I understand you to be saying is that if MERS held the title and then sold to another party, that party automatically becomes remote.
If MERS held a post foreclosure, a foreclosure deed, then yes, I guess I would agree.
Yes.
I'm not familiar that that comes up that often. I've never seen that.
It's not infrequent, and I think if you look at the cases, you will find that that's where some of our modern cases arise in contexts where, look at Bank of New York versus Bailey or Eaton, where the SJC is very clear that all that matters is who holds the title, based on the 1966 case.
If Diplomat holds title and they can't avail themselves of the summary process because of the limitations of the summary process statute, it doesn't mean that they're out of gas. It just means that they have to bring a plenary action under the regular civil rules, which they did in the prior pending action in their counterclaim in the Barnstable Superior Court.
What do you mean by a plenary action?
A full plenary action with multiple parties, the one that we filed in the Superior Court under the regular rules of civil procedure, not under summary process. And in that case, Diplomat filed their counterclaim for possession and use and occupancy, the duplicate complaint that they filed in this later case.
I was that in Barnstable Superior Court.
It's in Barnstable because venue's waivable, and we had an agreement with prior counsel, the co-counsel to Attorney Kingston, that the case would be brought in either Middlesex or Barnstable. We originally brought it as Middlesex, as you can see from the record, and then ultimately filed it in Barnstable. No one's objected to that.
If the statute doesn't provide for jurisdiction or venue in Barnstable County, the statute is very clear that an action in the Superior Court for possession has to be brought in the county in which the land exists.
Well, respectfully, I don't know, Your Honor. I believe that venue is generally waivable, but we didn't bring the counterclaim. That would have been Diplomat that brought the counterclaim. Either way, if they wanted to bring a claim in another.
You brought an action to challenge possession. They brought summary process in Worcester. You're saying under 12b9 they're claim splitting, and at that point they say no, we're not claim splitting, and there's no jurisdiction over summary process in Worcester.
Summary process.
Your 12, it impacts your 12b9 argument.
I see what you're saying, Your Honor. Yeah, so our argument is that they don't have standing jurisdiction to bring the summary process in the first place. Just a regular eviction matter is what they can bring, a regular eviction case under regular rules of procedure. Your Honor, if I may, just like to move along, the release agreement between the Lozanos and UJRC presents three additional jurisdictional defects. Number one, because Diplomat is not a party to the UJRC release agreement, they lack standing to challenge that. And number two, because the housing court's overall jurisdiction is limited under Chapter 185C, Section 3. Housing court jurisdiction is limited to matters pertaining to the health, safety, and welfare of residents of residential housing.
You challenged the relief. You challenged the summary process case by citing this release. So I think I'll stick my neck out here, and I'm speaking only for myself, but I think that if you assert that as a defense, there's a fairly decent argument that it falls within the summary process jurisdiction. I'm a little bit more concerned about how the book and page got changed in the UGRIC release of the $50,000 second mortgage. You indicated at the trial, at the motion hearing, that you had changed it in an effort to protect your client from foreclosure or eviction. Have I understood the transcript correctly?
No, Your Honor. Unfortunately, that's some of the misunderstanding that's happening when we don't have necessary parties and when we don't have due process. We would love to bring.
I'm talking about what you said at the
So,
hearing.
yeah. So what I was conveying at the hearing.
Judge, I'm trying to protect a client.
Yes, Your Honor.
Is that correct?
Of course, I'm trying to protect my client. Yes, Your
Okay.
Honor. But the
So
book and page number.
Here's my question to you. Did you
Yes, Your
inform any of the counsel to the parties to the release that you were changing that book and page number?
I never changed the book and page number, Your Honor. It was created from initially using that book and page number. That the language starts with the release claim further encompasses. That whole line was added. The release claim further encompasses the property located at 39 Knowlton. So the release claim pertains to the entire property, all claims against it,
No,
including
but there was
all mortgages.
a book and page number which you told Judge Winnick that you changed.
No, it wasn't changed, Your Honor. It was added to the release agreement.
All right, added. All right,
Yes.
all right,
The
all right.
yes,
You
and I
added that book and page number.
added that whole provision, that whole sentence.
Did you inform opposing counsel that you were adding that language?
I don't remember specific communications, but yes, we discussed it. I have emails going to them telling them that we're not settling this case without resolution of the first
That is
mortgage.
not my question. My question is, did you inform the other counsel in the case that you were adding this section with the reference to the book and page number to the first mortgage?
I don't remember specific conversation, Your Honor. We discussed,
Okay.
we understood that we were going to amend the contract. It was going back and forth.
Well,
This was the first round of drafting is when that got
how
put in,
could
Your Honor.
you release any claims on the first mortgage when the transfer to the Christiana Trust occurred before the release was signed?
Because UJIC is subrogating to the rights of the insured. It doesn't matter who the identity of the mortgage holder is.
But
The
you did
collateral
not bring
file
a-
transfers with the sale of a mortgage loan, and that
But you
includes
did
the
not bring
insurance
a-
policies.
You did not bring a subrogation claim, correct?
No, UJIC brought the subrogation claim.
Well,
the first
UGRC
one.
brought the claim. All right. Justice Grant.
I have a question about the record specific to your argument that there are disputed issues of material fact. At the beginning of the summary judgment hearing, Judge Winnick asked about an affidavit of your client, Crystal Himes, that was not signed. Are you relying on that affidavit to show that there's a disputed issue of material fact? And if so, where is it in the record?
Yes, Your Honor. It was my recollection that I think a signed copy was requested and it was followed up, and we filed that. And it should be in the summary judgment record or in the docket of the lower court.
But it's not in the record appendix before us?
I'm not sure where it would be located, Your Honor, but I'm happy to follow up and brief the court. I don't know that I can put my fingers on.
It's not cited in your brief and referred to as the basis of a disputed issue of material fact, and you can't raise a new issue now.
Well, Your Honor, we
I couldn't
have.
find it in the record.
And I don't see it on the document.
I have to look for that, Your Honors. Page 242 of the record is our statement of disputed facts. We were the only party that put in a statement of facts. DIPLOMAT did not even submit a statement of undisputed facts. So, we had some due process issues of what we were even disputing.
But we
They
do
didn't
not
follow
have
Rule
the
56.
signed affidavit in our record.
You have my signed affidavit. No, I don't know what happened. I'd have to double check on. Obviously, it's a very voluminous record. I don't know that it's not in there just offhand standing here talking to this court today, but I know that it was submitted in the lower court. It was part of the summary judgment record. And I believe I recollect that the judge asked for the signed version, which we submitted as well.
Well, yes, the unsigned version was submitted. The judge told you that it was insufficient and inadequate. You said that you would send one in. And
Correct, Your Honor.
I failed to see it on the docket. I may have missed it.
Yeah, it was electronically filed by my best recollection, Your Honor, but in the,
Okay.
And then at page 314 of the record, the judge made findings about that affidavit, but we don't have that affidavit before us. So what I don't understand is how could we find that Judge Winnick's findings about that affidavit are erroneous or leave a disputed issue of material fact when we don't have the affidavit?
well, again, I apologize, Your Honor. I was not aware that that was not in the record.
But it's
It
your
was-
burden to put the appendix together.
That is correct. It's a very voluminous appendix, as my understanding was, and it may very well be in there. I'm just, you're bringing this up to me on the cuff here, and I apologize that I've just, unless it's attached to the statement of disputed facts, it would presumably be part of our opposition to the summary judgment motion. So that's where I would expect to see it.
And it's not there. So the other thing that isn't here, and I'm curious as to whether you ordered it, is that part of your appeal is based on the denial of the motion to dismiss by Judge Horan she refers to in her margin endorsement to denial after a hearing. And we don't have the hearing transcript in the record that you submitted. So I take it that you did not choose to submit the hearing transcript of the motion to dismiss.
That is correct, Your Honor. We looked at the record, the briefs, and the law that would apply was for a failure to join a necessary party, if that's what Your Honor is referring to, or the prior pending action. The overall issue, obviously, with the lack of jurisdiction, all of the court's rulings would otherwise be void, regardless, because these are out. The UGRIC's release agreement falls outside the jurisdictional reach of the housing court.
All right, well, we've gone over largely on matters of housekeeping that we might have addressed at the end, but I think they're just as well addressed now. So thank you, counsel. And we'll now turn to Attorney Kingston, who may begin when she sees her 15 minutes, unless I didn't mean to preempt. Were there any other questions from the panel? So when you see the time clock, there you go. You may begin.
Good afternoon. May it please the court. Christine Kingston on behalf of the Appellee DIPLOMAT Property Manager, LLC. We ask that the court affirm the housing court's judgment as there were no errors of law or abuses of discretion therein. I'd like to start with the standing argument that my brother makes. He does cite to some very old case law, I think primarily this 1881 case of Warren v. James. My first argument would be this has clearly been at least impliedly abrogated by recent SJC case law. I think the most recent standing decision we have is Rental Property Management v. Hatcher. And the court was clear that standing is conferred if a party or person has ownership of a property or is the landlord. Even if we put aside this old case law, that related solely to the clause in Chapter 239, Section 1 concerning mortgage foreclosures. As we've cited in our brief, there was an additional clause added in 1952 for purchasers of real estate where the seller or the persons holding thereunder refused to surrender possession. My brother's argument is that this doesn't apply because the Lozanos are not holding under the prior seller. That's simply inaccurate. At the time of the foreclosure sale in 2016, the Lozanos became tenants at sufferance of Christiana Trust. When Christiana Trust sells to PennyMac, they become tenants at sufferance of PennyMac and so on. So at the time this property was sold to Diplomat, they were clearly holding under PennyMac to the extent they claimed any type of interest in the property. So as it's undisputed that Diplomat is the record owner of the property, has been since the time that this case was filed, we think there's clearly standing under Chapter 239, Section 1. The next issue, just briefly, is the entry of summary judgment for possession. We did file a certified copy of the foreclosure deed and affidavit of sale. It's our position that affidavit of sale clearly complies with the statutory form. Therefore, we did make a prima facie case for possession under Fannie Mae v. Hendricks. The burden shifted to the Lozanos to prove by affidavit or otherwise that there's a disputed issue of material fact. The only affidavit submitted by the Lozanos was this affidavit by Crystal Lozano, apparently not in the record appendix on appeal, but that, as Judge Winnick correctly found, did not create any disputed issues of material fact. I can relay to the court that the only piece of her affidavit that even related to the foreclosure was that she brought up this 2012 denial of a loan modification by a prior mortgager named City Mortgage. And that Judge Winnick addresses that in his order and says this was clearly a scrivener's error, that it says you've been denied for a loan modification because you've paid off the mortgage. Lozanos have never claimed that they actually paid off the mortgage. There's no evidence to that. So even if the court were to consider this affidavit of Crystal Lozano, that was insufficient to rebut our prima facie case for possession. So it's our position we never had to introduce any extrinsic evidence to supplement that prima facie case, but we did. We provided quite a bit of evidence, including proof that Christiana Trust held the mortgage by virtue of a series of mortgage assignments that complied with Chapter 183, Section 54B, and held a note at the time of foreclosure. And we also did bring the original note and the original mortgage to the hearing, which was inspected by Judge Winnick and opposing counsel. On the issue, just briefly, of the UGRIC settlement and release, we've talked a little bit about the intent of what, the Lozano's intent and UGRIC's intent. our point all along, and as Judge Winnick agreed, intent was irrelevant. If UGRAC did not have authority to release claims relating to the first mortgage, they could not have legally done that. And that's exactly our position. At the time this was executed in August 2016, and it was signed in September 2016, Christiana Trust had long been the record owner of the first mortgage. UGRAC, and this is clear from the mortgage discharge of the second mortgage, came to own interest in the second promissory note in the amount of $50,500. That's reflected in the mortgage discharge of the second mortgage, where it states that MERS is acting on behalf of UGRAC as interest holder under the second note. So it's abundantly clear that UGRAC's interest only extended to the second note in the second mortgage. It's clear from the face of the settlement and mutual release. Therefore, UGRAC could not legally release more than it held. In any event, Christian.
If I could stop you for a second, would you remind me at least, was UGRAC simply an insurer on the second mortgage, or was it the note holder or mortgagee of the second mortgage?
I can't speak to the insurer part of it. That's my suspicion. It did acquire interest under the second note. And we know that because of that mortgage discharge. And for however that happened behind the scenes, I can't speak to that, but the mortgage discharge of the second mortgage cites MERS is doing this on behalf of UGRAC.
All right. Now, as to the first mortgage, same question. What was UGRAC's status with respect to the first mortgage?
I have never seen any documents or information to suggest it had any role with respect to the first mortgage. To the extent it did, it certainly was never a holder of the mortgage or the note.
Okay, thank you.
So as Judge Winnick correctly found, clearly this settlement and mutual release could not have affected the first mortgage. It's legally irrelevant. Just briefly though, as the intent of the parties, I would note, and I think it's important to keep in mind, at the time the Lozanos signed the settlement and mutual release, and prior to Christiana Trust foreclosing on the first mortgage, there was active litigation in Worcester Superior Court filed by the Lozanos against Christiana Trust and its foreclosure counsel. They sought to enjoin the foreclosure. They did obtain a TRO and temporarily postponed it until November 2016. After the settlement and mutual release was signed by the Lozanos, but prior to the November 2016 foreclosure, the Lozanos never returned to the Worcester County Superior Court and said, first mortgage has been satisfied, released, and discharged, and you can't foreclose. They never did that. They had every opportunity to do that. Obviously, if they legitimately, genuinely thought that this release controlled the first mortgage in some respect, they would have done that. That would have been unimaginable that they would not have raised that. So they never did that. I think it's clear that they didn't actually genuinely believe it related to the first mortgage, nor could they. There's 3 express references to the second note of the lien in the agreement itself. Just lastly, there was a claim for damages brought by my client. The housing court entered damages in favor of my client. There was no countervailing evidence produced by the Lozanos about the rental value of the property. So the only evidence before the housing court was the affidavit from our property agent, Kimberly O'Donnell, that the property was worth $2,400 per month. And I do not think the Lozanos, based on my reading of their brief, even challenged the award of monetary damages on appeal. So we also ask that that be affirmed.
And you're seeking fees and costs?
I am. And this is something that I understand is not to be taken lightly. The reason why I'm doing that is primarily this obfuscation around the UGRAC release. I do not think there's a good faith basis to claim that this in any way affected the first mortgage, and it's the circumstances which even brought about the argument that's causing us to ask for our fees and costs. And that's not to say that there wouldn't have been non-frivolous arguments to raise on appeal. This is a post-foreclosure case, I'm sure there are, but they just simply weren't brought. And the brief focuses on these, primarily on this UGRAC release. That's the basis for our request for fees and costs.
There was a reference in the earlier argument that there was an agreement with opposing counsel to waive venue as to Barnstable. Is there any evidence of that in the record?
No, we never agreed to that. I can speak for my office.
I'm just asking about the record.
Yes, there's nothing in the record.
Okay, is there anything in the record to indicate that your client was aware of the fact that a reference to the book and page number of the first mortgage had been added to the UGRIC release?
For Diplomat or Christiana Trust?
Either.
No. Just briefly about the Barnstable County Superior Court case and excuse me, my brother's argument under Rule 12b-9. This was partially subject to the prior anti-SLAPP appeal. This panel of this court did find that we weren't aware of the fact that the Barnstable County Superior Court case was even filed before we filed this case.
No, we didn't find it because we can't find anything, but we know
very
that
imprecise of me to say, held and determined.
if there was a reference.
Yes.
There was a reference. But I see that there were emails in the record where there was a suggestion that your client, or at least your client's counsel, was unaware. Are those emails properly verified and properly considered as part of the summary judgment record?
Not in this case, I believe, Your Honor. I believe we would rely on the prior appeal for that fact. And I think that is a fact of judicial determination at this point that we were not,
So
we as counsel.
They were verified by affidavit at some point?
In the prior case, in the prior appeal, I'm not sure if that was done.
In this case, are they verified by affidavit?
The emails between counsel, I don't believe so. I don't believe so. At most, they would have been exhibits appended to motion papers.
Okay, and perhaps I have been overly resolute on one issue. Is there any place where you know of in the docket that the signed affidavit of the plaintiff was filed? Did that get e-filed? I know that dockets can be unreliable as well.
Yeah, I do know it was docketed in the trial court at docket number 81. I can't tell if that was a signed copy or not.
Well, the one that came in with the summary judgment motion is unsigned.
Yeah, I cannot tell whether that was a signed copy.
Okay. All right. Well, details. We'll figure it out. Are there any further questions or anything further that you would like to say, Attorney Kingston?
No, thank you. I'd otherwise rest on my brief and thank the court for your time.
Okay. Well, I thank both counsel for their arguments. We will take the case under advisement. Since it's now the conclusion of our sitting, I'd like to thank everyone who was associated with making the sitting happen. Our IT department, our clerks, our assistant clerks, our law clerks, and our interns. And a special thank you to the timekeeper today, who in our in-court proceeding, and to the IT department, and to the assistant clerks, and to the court officers for ensuring that all matters were reported in our morning session, and for their service to us always at the court. With that, the proceeding is concluded.
Custom streaming. And this is where I'm going to have to cut and paste. Yeah, it did. So it must be all done. But see, this is where you go live. And this is where I have to copy and paste. I have to copy these things over to YouTube. I know this thing, they do. It's just,